If you were activated to the Chicago mission, would you defy orders?
Absolutely. I would definitely say no.
Tell me why.
I mean, I'm not going to go against my community members, my
She doesn't feel like it. She thinks that's what staff sergeants are allowed to do in the military.
family, and my culture. This is a time to be on the right side of history.
In Illinois,
Listen to all the feelings. Article 3, the judicial branch, is supposed to be the apolitical, the non-political branch of government. That's why they're not subject to election. And because they're not subject to election, because they're not accountable to the political will of the American people, they're not supposed to be making political decisions. That would be tyranny. When you have people making political decisions who are not answerable to the American body politic, you have tyranny. What an awesome day to be alive in our great nation in America. All right, so today, Trump is rapidly closing in on 30th consecutive win at the U.S. Supreme Court. We're just a few away, but they keep adding up, don't they? A Supreme Court win here, a Supreme Court win there. Pretty soon you're talking about 30 consecutive Supreme Court wins for the great and powerful President Donald J. Trump. And I think the next of those victories is likely to come on the heels of this week's big win in the Ninth Circuit Court of Appeals, traditionally the most liberal circuit in America. Handed Trump a victory, as we covered yesterday, recognizing Trump's commander-in-chief authority to call out the National Guard, even over the objections of state governors and city mayors. Now, these same arguments are heading to SCOTUS from the various courts of appeal. American First Legal Foundation, founded in 2021 by Stephen Miller, the great and powerful Stephen Miller, senior advisor to the president. They filed yet another pro-Trump amicus, friend of the court brief with the Supreme Court, this time arguing in defense of Trump's commander-in-chief authority, making many of the same arguments that the Ninth Circuit Court of Appeals has already accepted twice in just a couple of weeks in upholding President Trump's authority to call out the Guard.
tell me what they're feeling right now.
So about 20,000 people in the military are undocumented or going through the green card process. Many of my soldiers are of the Hispanic community, and they did join to get themselves or their family documents.
So they joined out of self-interest. And now when they're asked to adhere to their duty to respond when called, they say no. It's not like our nation has not already dealt with this. The Supreme Court has already heard this case in which a member of the militia, what we now call the National Guard, declined to answer the president's call to service. He was subject to court-martial. He sued for relief in federal court. It went all the way to the Supreme Court. Martin v. Mott from 1827. A militiaman said, no, I don't want to go when the president calls. And the Supreme Court said, not only do you have to go, but when the president makes the call that you have to go, that's not subject to second guessing by anybody else, particularly not by the Article 3 judiciary. It is not subject to judicial review. So if I seem like I have confidence that the Supreme Court is going to come down on the president's side, like the Ninth Circuit Court of Appeals has on these National Guard questions, that's exactly why, for the arguments we're going to look at right now in the American First Legal amicus brief to the Supreme Court. In the Supreme Court of the U.S., Donald Trump versus Illinois, and they'll be arguing here, of course, for Trump's authority to call out the National Guard, and arguing for the well-established Supreme Court precedent that Trump's decision to call out the National Guard is not subject to judicial review. A plaintiff seeking a preliminary injunction or a TRO must establish a number of things. They have to establish the most important is that they're likely to win on the merits. Now, keep in mind, a TRO, temporary restraining order, or a preliminary injunction, as the name preliminary implies, is happening before the dispute is argued on the merits. It's happening before the trial itself. So one of the things you have to be able to show is a likelihood that when you get to the actual trial, you're likely to win on the legal merits. If you can't show that, you're not entitled to an injunction or a TRO. They also have to show that they're likely to suffer irreparable harm if they don't get the TRO or the injunction. that the balance of equities, what we call fairness, tips in the favor of the party that wants the injunction, and that emergency relief in the form of the injunction is in the public interest. American First Legal argues that the states trying to enjoin Trump on calling out the National Guard have shown none of these things, but were awarded a temporary restraining order anyway. They argue the federal government, Trump, is likely to prevail on appeal, and accordingly, this Supreme Court should grant the application to freeze the restraining order on Trump. Why is Trump likely to succeed on the merits? Well, the first and most powerful and most constitutionally sound argument is that he's likely to succeed on the merits because the courts have nothing to say about this. They have no power in the context of the commander-in-chief calling out the National Guard. The parties, the states, the lefties trying to stop Trump from calling out the National Guard asserted 9 different legal claims, each of which is a variation on the same theme for the federal courts to second guess the commander-in-chief, the president's determination that the conditions for federalizing the National Guard have been met. There is no express private cause of action to bring these claims, and for nearly 200 years, this Supreme Court has recognized that the president's determination is non-judiciable. In other words, not reviewable by the federal courts. They have nothing to say about it. The Constitution assigns to Congress and the president the power to determine when to call the National Guard to federal service, and that determination is not reviewable by the courts. It's a political decision, and the political branches of government are Article 1, Congress, and Article 2, the executive. Article 3, the judicial branch, is supposed to be the apolitical, the non-political branch of government. That's why they're not subject to election. And because they're not subject to election, because they're not accountable to the political will of the American people, they're not supposed to be making political decisions. That would be tyranny. When you have people making political decisions who are not answerable to the American body politic, you have tyranny. And this was of great concern to the founding fathers. They talked about it endlessly in things like the Federalist Papers when the Constitution was being debated prior to ratification. And everyone said, well, don't worry about the federal courts. They have very limited authority. They're an apolitical branch. Don't worry, we don't need to elect them. We can give them lifetime appointments because they're only settling cases and controversies before them. They're not making broad political decisions until now. Properly understood, whether or not to call out the National Guard is a political decision, not judiciable, not reviewable by the apolitical Article 3 courts. He's supposed to be held in check by the American body politic. They can refuse to re-elect him. He can be impeached by Congress. Congress can pass a statute changing the president's delegated militia authority. There are many political ways to hold in check a president who's overreaching in his use of the militia power, but it has to be a political check on a political exercise of power, not a tyranny of the apolitical, unelected, black-robed, tyrannical, inferior district trial court judges. Under the Constitution, the states, including the plaintiff state of Illinois, representing Chicago, fully ceded to Congress their power for calling forth the militia. In the Constitution, it says the militia power is removed from the states and placed in Congress. Every state that ratified the Constitution in 1791 agreed to this condition, and every state that joined the Union since then was required, again, to agree to this condition. The states, as independent sovereign nations, had their own power to call forth the militia, but when they became states of the United States, they gave up that power to Congress. It's found in the U.S. Constitution, Article 1, the legislative branch of government, Section 8, Clause 15. And then Congress delegated portions of that power to the Article 2 president, who is the commander-in-chief of the militia of the several states when called into actual service of the U.S., found in Article 2, naturally enough. And Congress delegated this power to the president In this case, using the statute 12406. There are other means the president can use to call out the National Guard, including the Insurrection Act. But in this particular case, calling out the National Guard to Chicago and Illinois, Trump used 12406, as he did in California, as he's done in Oregon. 12406 authorizes the president to federalize units of the National Guard of any state in such numbers as he, the president, considers necessary when he finds that any one of three conditions is present. Now, the three conditions are foreign invasion, that doesn't apply here, or when there's a rebellion or a danger of rebellion, which does apply here, that's section 2 of 12406. And then section 3 of 12406 is when the president finds he's unable to carry out the laws with the regular forces. Here, the president, Donald Trump, determined that third condition is present in Illinois and particularly Chicago, that the president is unable with the regular forces to execute the laws of the United States. And he documented that in a presidential memorandum just a couple weeks ago, October 6th. That determination by the president is non-judiciable, that he's unable with the regular forces to execute the laws, as this court held in Martin v. Mott, the case I just talked about when we talked about the National Guard woman who says she won't respond if called to Chicago. As this Supreme Court held in Martin v. Mott, once Congress has authorized the president to call forth the militia when certain exigency conditions are present, the authority to decide whether the exigency has been met belongs exclusively to the president. This is quoting the Supreme Court decision of Martin v. Mott. The authority to decide whether the exigency has arisen belongs exclusively to the president, and his decision is conclusive upon all other persons in the universe. Illinois and Chicago creatively packaged their request for an injunction against the president's determination in 9 different boxes, but all of those invite the unelected black-robed tyrannical inferior district trial court judge and this Supreme Court on appeal to violate Martin v. Mott by purporting to review and invalidate a decision that Supreme Court precedent has held is assigned to the political branches. As scholars have recognized, Martin v. Mott held that Congress gave the president sole and unreviewable authority to determine when an emergency exists that is sufficient to justify deploying the militia. The unelected black-robed tyrannical inferior district court recognized Mott's holding, but then dismissed it, suggesting that this Supreme Court did not really mean what it said and had only issued a reaction to the challenger seeking review. The Seventh Circuit seemed to agree, the Seventh Circuit Court of Appeals, but this Supreme Court's opinions and holdings are not tickets good for one ride only. The rationale and holding in Martin v. Mott, it's weird, sometimes they call it Mott and sometimes they call it Martin. They should pick one. And they preclude judicial review here. The plaintiff section 12406 ultra vires claim is improper under recent Supreme Court precedent. Ultra vires means that the president's calling forth of the guard is a clear violation of statutory law. Chicago and Illinois' ultra vires claims are non-justiciable for the additional reason that there is no ultra vires cause of action to review the president's determinations under 12406. First of all, ultra vires only applies to agency action, and the president's not an agency. So it's unclear whether ultra vires review is available at all. That's because ultra vires action is a suit in equity, and courts generally lack the authority to enjoin the president, meaning Article 3 courts would be committing a separation of powers violation if they issue restraining orders against the president. The federal courts have been getting around this prohibition by, when they issue their TRO, excluding President Trump as a party constrained by the preliminary injunction or the TRO, but simply listing all the president's subordinates, as if that makes a difference, as if the president is supposed to be George Washington in 1792, getting on a horse and leading the National Guard troops himself. By enjoining his subordinates, they're obviously effectively enjoining the president. To be sure, the Supreme Court has assumed, without deciding, that some ultra vires claims may be upheld against presidential action, but it is held that such review is not available when the statute in question commits the decision to the discretion of the president, and there's no doubt that 12406 does that here. In any event, this Supreme Court has strictly limited non-statutory ultra vires review, emphasizing just a year ago that it applies only when the defendant has taken action entirely in excess of his delegated powers and contrary to a specific prohibition in a statute. None of that is happening here. Ultra vires review does not apply simply because someone has arguably reached a conclusion which does not comport with the law. That's to be argued out on the merits. If a decision is of the sort that is within the decision maker's jurisdiction, ultra vires review is unavailable. In other words, it's only for a clear exceeding of power. For example, if Trump were to issue an executive order telling the Supreme Court how to rule on a case, that would be ultra vires, clearly outside his authority. If the president were to issue an executive order telling Congress how to vote on a bill, that would clearly be ultra vires beyond his authority. But nothing like that is happening here. Ultra vires is unavailable here because there are no specific prohibitions in 12406, because the president's decision to federalize members of the Illinois and Texas National Guard is exactly the type of decision that the statute contemplates, and that Chicago and Illinois are improperly attempting to dress up a typical statutory authority argument as if it were an ultra vires claim. 12406 speaks only in the affirmative. It doesn't prohibit anything. It provides that the president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary whenever any of three conditions is present: foreign invasion, rebellion, or danger of rebellion, or unable to enforce the laws with the regular forces. No one disputes that this provision gives the president power to federalize the National Guard under certain conditions, so federalization cannot be entirely in excess of the powers the statute confers or beyond the president's jurisdiction, even if none of the requisite conditions is present. So the courts cannot conduct ultra vires review of the president's invocation of 12406 to federalize the National Guard by arguing that none of the requisite conditions is present. But even if we said that the courts could review the president's action under 12406, even if the claims were judiciable, none was likely to succeed on the merits, any of their 9 claims. The amicus here, this brief, focuses on the challenge under Section 12406 because it provides the underlying premise for all of Chicago and Illinois' feckless claims against the president. The president acted properly under 12406. Again, the statute authorizes the president to federalize the National Guard when the president is unable with the regular forces to execute the laws of the United States. That's the third condition. And the president found that the regular forces of the United States are not sufficient to ensure the laws of the U.S. are faithfully executed. That's the October 6th memorandum. If the Supreme Court reviews that determination despite the prohibition of its own precedent in Martin v. Mott and the Constitution's commitment of the determination to Congress and the president, then the Supreme Court's review must be especially deferential to the president. And that's right from the Ninth Circuit's Court of Appeals decision against Gavin Newsom just a couple weeks ago, Newsom v. Trump. Under that extraordinarily deferential review, events amply demonstrate that the regular forces of the United States are unable to execute the federal immigration laws in and around Chicago. Surely the president may determine that regular federal officers are unable to execute federal laws in Chicago when even the Chicago police superintendent has acknowledged illegal obstruction of federal law enforcement. Accordingly, the unelected black-robed tyrannical inferior district trial court judge committed error by finding that Chicago and Illinois were likely to succeed on their claim that the president violated 12406 because, according to the court, no factual circumstances satisfy any of the predicates of 12406 in Illinois. Obvious nonsense. The unelected black-robed tyrannical inferior district trial court and the Seventh Circuit Court of Appeals repeatedly invoked Illinois' 10th Amendment interests, both on the merits and in the context of irreparable harm. But it makes little sense to categorize this dispute as implicating the 10th Amendment or state sovereignty. Under the Constitution, the states fully ceded to Congress their power to call forth the militia to execute the laws of the United States. That's all permanently embedded in the Article 1 legislative branch, which then, as we've seen, has delegated much of that authority to the president, as they're free to do. The Constitution assigns the power to call forth the militia to Congress, and Congress has delegated portions of that power to the president. Again, they're quoting here the recent Ninth Circuit Court of Appeal win for Trump. It is the clearest expression of federal power to constrict citizens. Anti-federalists had attempted during ratification debates of the Constitution to interject state governments into the militia process by requiring some form of state-level consent, but those efforts failed. The states have no veto power over the federal government calling forth the militia, what we now call the National Guard. Accordingly, any presidential action calling forth the National Guard, contrary to federal statute, might implicate Congress's power. Congress might have a complaint. They have the authority under the Militia Act. Maybe the president overreached and infringed on Congress's power, but it cannot be an offense against the states, which fully transferred their militia power to the federal government. It would be like states arguing the 10th Amendment harm from alleged violations of federal statutes enacted pursuant to Congress's power to regulate commerce with foreign nations. Another power the states fully ceded to Congress. This was a critical misunderstanding of the balance of powers between the federal and state governments. And frankly, it's a misunderstanding that if I were grading a first-year law school student's paper, they'd get an F. That's how obvious this error is. That's how severely these feckless Trump derangement syndrome federal judges are twisting the law to get the outcomes they want. Everybody knows the militia power was ceded by the states to the federal government. There's no credible dispute of that legal reality. There is no 10th Amendment claim here, and yet they pretended that there was. This was a critical misunderstanding of the balance of powers between the federal and state governments with respect to militia activities, and it infected numerous aspects of the lower court's opinions, including, most relevantly, their view that Illinois had suffered some type of irreparable 10th Amendment harm. Remember, irreparable harm is one of the conditions required for getting a temporary restraining order. The state of Illinois has not suffered a 10th Amendment harm, certainly not an irreparable 10th Amendment harm. The remaining factors favor the governments. Chicago and Illinois speculated below that deploying the National Guard in Chicago will injure Illinois sovereignty, increase unrest rather than quell it. Chicago and Illinois are saying the real problem here is not our lawlessness and our defiance of federal immigration law and our violence against federal officers carrying out their duties. The real problem is the federal officers executing federal law and depress business activities and tourism. But the Ninth Circuit has already rejected similar claims from Los Angeles as too speculative, and further recognized that any alleged sovereign harm is in essence a merits argument that's argued on the merits during the full-blown trial, and not something that's argued in a preliminary status like a TRO or a preliminary objection. Trump, the Article 2 executive branch, are the ones who now face irreparable harm thanks to the lower court's temporary restraining order. The federal government has an uncontested interest in the protection of federal agents and property and the faithful execution of the law, and that interest is irreparably harmed by the violent and subversive acts of so-called protesters that drew the Chicago police superintendent's criticism and led the president to mobilize the National Guard. Finally, the equities, the fairness, and public interest factors also favor throwing out this TRO. The TRO of the unelected black-robed tyrannical inferior district trial court judge undermines the public interest in protecting the Constitution's assignment to the federal political branches, not to the judiciary, of the power to determine whether to federalize the National Guard. In other words, there is a strong public interest against the judiciary purporting to veto the president from acting pursuant to an express authorization of Congress. That is all the more true where, as here, the unelected black-robed tyrannical inferior district trial court had a scant record before us. In other words, it was done on a preliminary record, without witness testimony, without all the things that a full-blown trial would bring. The public also has an interest in ensuring that so-called protesters do not hamper enforcement of federal immigration law. It would not be equitable or in the public interest to allow the state to violate the requirements of federal law. The federal government also has a paramount interest in protecting the territorial integrity of the United States, quoting a Supreme Court decision here from just this generation. And this Supreme Court has explained that the equities favor the government when an injunction unnecessarily imposes a serious threat to national security. Another Supreme Court decision. All of those interests are present here in spades. The equities and public interest thus favor throwing out this temporary restraining order. And so this Supreme Court should grant our application to throw out the temporary restraining order and allow Trump to send in the National Guard to Chicago and Illinois, just as he's been allowed to send in the National Guard into Los Angeles, just as he's been allowed to send in the National Guard into Washington, D.C., just as he's been allowed to send in the National Guard into Portland, and will soon be allowed to send in the National Guard to San Francisco as well.